Hey everybody, good afternoon. We are Thursday and I'm here with 𝐏𝐞𝐧𝐬𝐞𝐳. She's a notary that I do business with here in Montreal, and we just came out of a meeting actually, and we're taking a few minutes extra today to speak about, well, you guys saw the topic, to speak about, different scenarios that may arise when you inherit a property, or it's you're a liquidator, or you've been mandated to sell something in a succession. There's a lot of different scenarios, and often I'm asked by kids that have a property. They ask me all these questions. I have a will. How does a mandate work? Can I just sell it? I think it's mine anyway. We're waiting for the notary to prepare certain documents and all that. So I'm taking the opportunity, and thank you to Jessica to agree to kind of share with everybody some information on this. So Jessica, what can you tell us about what you hear a lot in the boardroom? When clients call you and say, I just inherited something, I don't know what to do. What's the first step?
Okay, well, first of all, thank you, Sal, for having me here today. We're having a great time this afternoon. Basically, obviously, the best thing to do if ever something happens, a loved one passes away, and you are handed the will and you realize that you are the executor, you're the person that's in charge, that's when you would basically get in contact. If, let's say, you have a house in the property, in the estate, sorry, contact first, obviously, your agent, because they're best placed. They are going to know what documents that you need. You don't want to just right away, let's say, go du proprio and put it on the market without necessarily having all the necessary documentation. And
work with a broker.
Exactly, definitely. They're experts in the field, just how they work with us often. So right away, if ever even Sal has questions, he calls me. We work together to make sure that once we're at the point of listing, you have everything that you need, and there won't be a roadblock if you find a buyer that's really excited and that's ready to sign, and then all of a sudden we're missing certain documentation. Yeah. We might have to postpone the sale, which could
very bad.
Really not really good for.
No, because there's a buyer that thinks they're buying and now they can't sign because the paperwork wasn't done properly. Actually, I know the answer to this. So the first document that you have to draw up and create when someone inherits a property is the declaration of transmission, right? Yeah. Can you explain what that is?
Yeah, so basically when someone passes away, their assets go into the estate. So we basically need to legally transfer the immovable, which is the property, the home, from the estate to either the heirs or from the person that has passed away to the estate. So we have to do that by doing a declaration of transmission. So definitely that's one of the main documents that you're going to need to have drafted by a notary that'll transfer the right of ownership into the estate so that you as an executor could sell the property, or even if it's transferring it to the heirs so that the heirs can then sell the home. Definitely you need also the death certificate. That's one of the, it sounds silly, but it's one of the documents that you need. Yeah. And a will search to make sure that the will that you do have is the last standing will, because that could happen that there's another will somewhere that you weren't aware of, that you think the one that you have is the last standing will. It might not be.
Does that ever happen, that people bring you a will that they think was the last one and you do some searching and find another one?
It has happened, yes. Wow. Unfortunately, which sometimes it's not a good surprise.
Just like what?
Yeah. Exactly.
What do you mean? The neighbor?
Yeah. Exactly.
That's not good. So the declaration of transmission. So for me, when I meet clients, it's exactly what Jessica said. The first thing I ask them is, do you have the declaration of transmission? That proves to me that a notary did all our homework, and it kind of green lights it for me that we can put it on the market, even though it's still in the name of the past owner that most likely passed away, that did pass away. So declaration of transmission, we have that document now. What about, I sit down with clients and I'm asking you because it happens all the time. People get very confused. They tell me they have a will, and they think the will allow them to sell the property if their example parents are still alive. Okay. They think, well, I have the will, I'm allowed to sell it. Yeah. So can you kind of explain a little bit the will and all that?
Sure. Yeah, that's a good point. It's actually happened to me as well that happens. Basically, the will can only be used if the person passed away. So that's really important. So just because you have a will doesn't mean you have power of attorney or you have authority over your parents' things if they're still alive.
Yeah.
So what they need, if your parents are a little bit older and stuff, I'd highly recommend that they get done either a power of attorney, which will give you power to act as soon as it's signed, or a mandate in case of incapacity, which is basically once someone is deemed incapable, I have authority over their things and then I can sell the property. So really there's two different documents in a sense. There's the mandate, the mandate in case of incapacity, and then there's the will. So it's two separate things. A better way to think about it is the living will. They call the mandate a living will. It's an easier way to sort of think about it, that I'm still alive. I can unfortunately not make my own decisions. Who's going to act for me? That's a different thing than the will.
That's a great point you bring, and it's happened to me actually recently in one of my files where they didn't have a mandate of incapacity.
Okay.
I was telling them, go see a notary, get it done, because knock on wood, things can change. And sure enough, it did. They don't have it. So what happens when someone becomes officially incapacitated? In French, it's a mandat d'inaptitude, which means the doctor says this person officially with a document cannot make their own decisions.
Right.
What happens if that happens and there's no one, that person never named someone officially? Isn't it automatic that the spouse can decide for them or the kids can just decide for them?
No, actually, that's a good point. It's not automatic. What happens if I am deemed incapable and I don't have a mandate in place? We have to do what's called the opening of a protective regime. So basically, you need to get 5 loved ones, so spouse, kids, friends.
It has to be 5?
Yeah. 5. If there are cases where you exceptionally make it 3, let's say.
Okay.
If let's say you have family that's you don't have enough family or friends around the person,
you can bring it down.
You can bring it down to 3, and then they have to get together and basically name someone to act for you. This takes a long time. It's extremely costly. Basically, it's a long process.
How long can it take?
It could take up to a year.
Oh.
Yeah, it's a really long time,
That's a long time.
Because we have to basically, it's put in place to protect the person, right? Since they didn't themselves decide who they're going to name, well, everyone, the family, close friends have to get together, nominate someone, and then the notary will draft up the document and submit it to the court. And then the court has to say, okay, we approve this. This is in the best interest of the person. And so now, whoever I named can act for me.
And this, by the way, this mandate of incapacity is not just for selling property. If the person, example, is not well and there's medical decisions that have to be taken, well, you can't just say, I've decided now for my mom to do this procedure or do that step in the hospital. That you have to decide for yourself. And if they're not able to, you have to wait it out and get the government involved with the notary. It could take up to a year. Imagine you have a house you want to sell, example, and you're not even allowed to sell it if you wanted to because this little paper wasn't drawn up. When everyone knows that your mom or dad most likely would have had you speak for them anyway. Yeah. So these are like horror stories.
No, for sure. I'm sure you've seen. I don't know. Have you ever seen a really bad situation?
I've seen one case where those 5 people couldn't agree, and the government kind of stepped in and. The government kind of stepped in the end and put it for sale, and somebody was mandated by the government to kind of sell it. It was a bit of a mess. This property. When I wasn't involved, but I heard about it. Most of the time, people take my advice to come and see a notary and just get all the paperwork in order, because these are the documents that you wish you had done when you need them, but you're like, I should have done it. But when you figure out you should have done it, usually it's too late. And you cannot. Once someone is incapacitated, you can't there's no tricking the system. You can't just nod your head or I agree. No, it's the doctor. That's it. So save yourself some headaches. And if, in your family, it might be a difficult discussion to have at the table. I understand that, especially with Italians, to bring up these things, who can speak for you, or wills, and these are not easy conversations. However, they're for everyone's best interest, especially the person that your mom and your dad. So look at this scenario, look at your paperwork. Now, power of attorney, I know there's full administration. Yeah. So can you explain the differences? What, some people, they say, I have it, and they don't realize that they still don't have the right to do certain things?
Yeah, for sure. So the power of attorney, so basically, just to recap, there is the will when you pass away. There's the mandate in case of incapacity. You're no longer capable. You can't make your decisions. And there's the power of attorney, which is I am capable. I can make my own decisions, but I want to name someone to take care of my things. A lot of times I'll have clients, especially Italians, they say, oh, I have a power of attorney at the bank, so it's fine, everything's okay. But unfortunately, no, that's a specific power of attorney that's done at the bank that allows your son or daughter to do things for you.
Yeah, there's their marriage contract, there's the gold, and there's the power of attorney. It's all at the bank.
Yeah, exactly.
They have it, and a little bit of, maybe a little bit of cash inside the safety deposit box.
So yeah, exactly. But what we can do is we can draft, let's say as notaries, a power of attorney that's general. And it can be tailored, obviously. It could be tailored to be specifically just to sell the house. Let's say you have parents that are often in Florida or something, or often on vacation and can't really be there to deal with the selling of the family home, that you need to step in. So they're completely capable. They can make their own decisions, but they're not often able to, let's say, walk to go with the visits or things like that. Then you want to take care of that. Well, of course, we can draft a power of attorney that gives you the power. So even if your parents are capable, you could still act for them and sell the home with that power of attorney.
That I have to add that's happened to me quite a few times. By the way, if you have any questions, guys, if you write a question, I think myself or surely Jessica will be able to answer. But to add on what you just said, a power of attorney is sometimes a lot of people, they think that they have that document and they could just sell the house. The person's in Florida, they don't have to know about it. It's just, I have the right. It's like they treat it as if it's their property. Yeah. It's not the case. No. The power of attorney, like Jessica said, it just means that the owner is not physically able to be present, and they're saying he can sign for me. But am I wrong to say that you'll call?
Of course, yeah.
And say, hey, Mr. X in Florida on the beach,
yeah.
You know your son is selling your house?
Of course. 100%, exactly, definitely. When it comes time to the actual transaction, the notary in the file and even the agent will do their due diligence, and they'll make sure that they reach the person that gave the power of attorney. Hey, are you sure that we're selling the house? That kind of thing. Same thing. We'll also reach out to the actual notary who did the power of attorney to make sure that it hasn't been revoked or something like that. And obviously, power of attorneys, you can't just give the property. It's always, in the best interest of the person, and it's for a sum of money that you're going to use that power of attorney for.
That's great. One other thing that just came to mind.
Yeah.
What do you recommend when they're about to decide, like the family, this person could speak for me, or what if they have like 5 or 6 kids? I've seen horror stories where the parents, to be fair, named almost all of them,
yeah.
Which is almost like gridlock, right? Yeah. There's never a 100% agreement.
No,
it has to be done. So what do you recommend when there's more than one sibling or two, for them to? What do you recommend, or what do you think is the best move?
I mean, look, we try as best we can as legal advisors to guide our clients. Obviously, we always will, in the end, respect what our clients' wishes are. Definitely. The ideal situation is naming one person, just because it's a lot easier. You don't have to always check back and forth. Obviously, if you do have multiple children, maybe sometimes I will suggest majority vote. If you could put 3 people, so that at least if ever there's an impasse, there's a tiebreaker. Because a lot of times we will put our kids acting jointly, but it could happen that they're not on the same page. So, I try the best to steer my clients to say, look, is there not maybe, you can explain to your children why you've made that decision as well, because sometimes that's what they worry about. Maybe that my daughter might be offended because I named my son as the power of attorney or something like that. You can always explain to your kids, like, this is what I think will be easier. But of course, you could have them both acting and both being together as well. But it definitely can be difficult. But if you have 5 kids, at least if you do a power of attorney, don't put all 5, try to put like 3.
It's going to cause like a lot of confusion.
Exactly. You could put them as replacements, so there's still like a recognition there that you are putting them in. You know what I mean? It's easier for sure if you can narrow it down. That's good advice. What about a will? Like, in terms of timeline, people they'll say, I have a will that was drawn up in '84, and then it's being read in 2018, 19.
What's the general rule? Like, should they be updated, or are they, no matter what, they're always valid?
Look, for sure, no matter what, they're always valid. So good job to every people that have them, even if they're quite old. The way that we draft the wills, we try and make them have a long lifespan, in the sense of I leave everything to my spouse. If he's not there, it goes to my kids. If they're not there, it goes to my grandkids. So it can have quite a long lifespan, the document itself. I recommend, I say every 5 years though, just to like look at it, you know, make sure nothing's changed, because sometimes we might name an executor because our kids are younger, they're 10 and now they're over 18, and maybe we want to change it, like update it a little bit, and we don't necessarily have to redo it completely. You can also do what's called a codicil, or anyways a little modification if it's certain things that have changed in your life that we want to remove. Do you know what I mean? Or change.
Exactly. So basically, updating your will is a good idea.
Yeah,
these are not expensive things
no,
to do, guys.
That's why it's unfortunate, and I'm sure, like you said, you see it a lot. It's always after the fact when families go through difficult situations, then they didn't have the right documentation in place or didn't follow the right procedures, and then they realize, oh my gosh, now I need to get a will now, because they unfortunately experienced bad situations with their family. So, and for the amount of not time and money that it costs just to do a few of these documents, it's not it's worth it for the less headaches that you have and everything. And
like people don't fall. A lot of people don't do any of this stuff, and they hit the roadblocks. It happens to me.
I'm sure.
I get like a call, and there's a block number, and it's like, I have a question. They don't give me their name, and they're like, what if someone you know dies and the house is let's say the brother, and they're getting all like detailed about the questioning, but they don't want to say it's for them. It's because they're realizing they're in a jam, and they're not sure what to do. And it's very delicate inside a family about, this is a delicate topic. So to sum it all up, guys, deal with a notary, deal with a broker. That we do this all the time. We're very accustomed to the process. If we're not sure, we know, we ask questions, and we know where to get the right information. But we've done it a million times, especially for me, and I know Jessica as well. So you're in very good hands. It's the job of selling that property or being the liquidator. It's a huge responsibility. Don't leave it up to chance. A mandate of incapacity, a living will, is very important. There's no reason not to have one. Could everybody have a will? And who shouldn't have it? Or everyone should have a will. Everyone. You know. What about only when you have kids?
No, you should have a will, right? You know, no, because I mean, you might have properties. There's all sorts of things that you need to protect. And again, if the cost is so minimal compared to if ever, God forbid, something happens and you pass away without it, I mean, it's not even comparable. The amount of cost and headache, and I mean, you're dealing with the loss of someone, and then you have to realize, oh gosh, I have to go see the notary a million times to get all these documents drafted since the person didn't have a will. It can create a lot of hurt as well and pain. And especially when you have a lot of large families and stuff, it's better that you decide these are your decisions. They will be respected, and that's it. And you know,
a lot of times, like on a little bit of a funny note, a lot of times people pass away, and they don't want to call anybody because they know that it's gonna freeze like the bank account. Everything's gonna get frozen. So like it's almost like hush hush that someone just passed on and all that. But that's just a funny thing that happens. But nonetheless, guys, you're in great hands with Jessica. If you need any information, thank you, myself as well. If you need more information, reach out to us. And that's it. So I hope this video was informative for all you guys, because I know, honestly, for me, in the last 5-6 years, there's a lot of this going on. Especially in the East End, we have a lot of empty homes that either the owners have passed away, or they have gone into the residences, or have bought a condo, or nonetheless they're no longer in the house because they couldn't stay there no more. It was too big. I've seen homes where owners in cottages have no longer go upstairs to the rooms because they can no longer walk up the stairs. So they're actually sleeping on the main floor. So this demographic that bought in the 70s and 80s that now has turned 70 years old, the homes the homes have outgrown them. They're just too big. So we have a lot of empty properties. A lot of people asking questions of what to do with the house. I just met a family this morning, two brothers, that it's 1.5 years the house is empty. And there's a lot of emotions there. Like, you know, one of them was saying, I feel a bit guilty selling the house, but the owner is placed and is not well. So having an empty house is not a good idea. And I want to add, and as my 𝐏𝐞𝐬𝐧𝐬𝐞𝐳 insurance broker, John Coriorazza, just going to plug in there, you have to advise your insurance company if the house is empty, right? Because there's a clause in your contract, most likely, correct me if I'm wrong, anyone, there's a clause that says that you cannot leave a house unattended for, I think, 30 days or something. So having an empty house for 4 or 5 months, not telling your insurance company, well, guess what? That is their back door not to pay you in the case or in the event of a claim. Because if you've agreed in your contract that nobody probably ever read, to not leave it unattended, and then you've left it unattended for 6 months, or it's empty, and they realize, example, during a fire, the insurance company comes and sees and say, hey, where's all the furniture? Oh yeah, the house has been empty for 1.5 years. Horror stories I've heard of, guys. You don't get paid. So please call your insurance companies if you're managing properties that are empty while you're waiting to make the decision of selling them, and let them know they're empty. So not corrected, but protect yourselves. Make sure they know. A lot of times they'll give you a grace period of 30 or 60 days with no change in the rate, just while you sell it. But eventually the rate will go up, and it could almost double from what I've heard from different people. It could go up, but it's, see, John just tagged in there and he said, absolutely. So speak to your insurance agent about this, but definitely don't keep it under wraps, because you're taking a tremendous risk having these properties left empty, okay? So on that note, I know Jessica has clients waiting. I have to run and meet more clients. If you guys need anything, please reach out and let us know if there's anything in the world that we can do for you. Have a great day.